Welcome to Legal AF on the Midas Touch Network, the Court Accountability Action. My name is Mike Sachs. I'm a senior advisor with Court Accountability Action, and I am joined today by Professor Jill Lepore, the author of We the People. She's a professor at Harvard University. And Professor Lepore, thank you for joining us today.
Yeah, thanks so much for having me.
Yeah, so I've been really excited to talk with you about this book. I've read your other books, and this one is no less of a tome, but it's also no less informative and really eye-opening. You cover a lot in this, the amendment process, failed amendments, it's the history of the Constitution. But I kind of want to get into a specific segment that you talk about here, which is how originalism, which is the dominant mode of interpretation among right-wing and conservative legal movement, how that came to be a thing. So I'd love to ask you first, how did it come to be a thing?
Yeah, I mean, I wish there was one simple answer. They're really a series of tangled together stories. So originalism doesn't come by that name until the 1980s, when it also reaches, the public world, right? So most people think of originalism rising to American popular consciousness in 1987 when Robert Bork is nominated to the Supreme Court by Ronald Reagan, which is also the bicentennial of the Constitution. So everyone's waving around, copies of the parchment Constitution. And Bork really presents originalism to the world on C-SPAN, and people are watching because it's pretty lively. It's like Joe Biden asking Robert Bork these questions, and he gruffly with his big beard and professorial demeanor, lectures America on the meaning of the Constitution. And then, of course, he's defeated. But it's still quite a galvanizing moment in the history of the Supreme Court. But I think if we start there, we really miss originalism, the idea that any document should be interpreted by what the people who wrote it meant at the time or how it was read at the time. Any historian would agree with that, right? Like that's one of the ways that we read old documents, right? If you read a letter that your grandmother wrote to your grandfather, you want to, what was she thinking? Why did she write it? Who was she anyway, right? Like we all ask those questions. But originalism as the claims that originalism makes in the 70s, really coming from Bork and also Antonin Scalia, and then becoming again known to the public in the 1980s, are that there is only one way to read the Constitution, and it must be one true way. Everything else is heresy, right? There's a lot of kind of religious trappings to originalism. It has a lot to do with fundamentalism. It has sort of similar intellectual origins. So it's not just like, oh, of course we have to think about the document, who wrote it, what do they mean by it? It's like we have to think about it in this narrow, precise way. No other evidence means anything to us in how we understand what the law should be and what the Constitution means in our day. And so in that sense, you don't see that much originalism over the course of American history. That's a kind of unusual position for any judge or justice to take over the course of American history. There are moments of it, right? Like Dred Scott in 1857, the Chief Justice says, oh, we can't think about whether blacks and whites are equal or whether this slavery was wrong or ever was wrong. We can only think about what did the framers mean? They meant for that no black person could ever be a citizen, right? That is, in that sense, an originalist or interpretation, right? Dred Scott. So you see modes of that.
And yet, let me interrupt for a second. And yet, everything you just said, in that it wasn't even part of the interpretive tool set, or the only one of the founding generation, suggests that originalism itself is kind of anti-originalist.
Yeah, it's really, there's no, if you think about it for half a second, there's no way it really can be original, in the sense that the early Supreme Court wouldn't have had access to the documents that originalists insist are the necessary documents for finding the original intention, meaning, and understanding of the Constitution, right? The Madison's notes on the Constitutional Convention weren't published until after his death in 1837. The Federalist Papers were published in New York newspapers. They were later published in Bound, but they weren't that common. The notes of the state ratifying conventions, which originalists are all about, a lot of those weren't published till the end of the 19th century. They're just, you kind of need the internet to be an originalist. Do you know what I mean?
And yet, or you have to be a real obsessive who's going to go through all the archives and selectively pull out various things that justify one's position about originalism when you're pissed off about, say, how Brown v. Board was decided, which seems to me to be the modern origin story of originalism. It
Yeah.
lay dormant after Chief Justice
Yeah.
Taney purported to discover it for Dred Scott to say that black people had no rights that the white man was bound to respect.
Right.
But it lay dormant for a while until the unanimous decision of Brown versus Board of Education.
Yeah, and so what's really interesting,
in
so Brown really is the inflection point. So Brown, if you recall, is argued twice because also the Chief Justice dies and Fred Vinson dies of a heart attack quite suddenly. I think Felix Frankfurter then says, "This is how we know there is a God." The court was really divided on Brown, and the question
5-4, I think they were close
seemed to turn on whether the framers of the 14th Amendment did or did not intend for it to prohibit segregated schooling. The framers of the 14th Amendment were the people in the 39th Congress who drafted, debated, and passed the 14th Amendment. And so what happened, Vinson had sort of sent the case back for re-argument, and when Earl Warren became Supreme Court Chief Justice, he, relying on memos that Vinson had and Alexander Bickel, who was Frankfurter's clerk, had, asked both sides to answer a series of, I think it was like 6 or 7 questions, and they're all about the history of the 14th Amendment. And so the side arguing for segregation comes in and kind of blithely quotes Dred Scott, which as like a model case for how to interpret the Constitution, which is a really shocking thing. Even in 1953, 54, that was a shocking thing to do. But then, they say like, okay, well, if we look to the framers of the 14th Amendment and we look to the original Constitution, the historical evidence makes clear that segregation is entirely constitutional, and in no way did the framers of the 14th Amendment ever intend for it to prohibit school segregation. And the NAACP, Thurgood Marshall, and the team of lawyers that are arguing the other side do, of course, famously a couple of different things. One thing is they insist that the framers of the 14th Amendment, that there is a way to understand the 14th Amendment and its framing as having been meant to prohibit segregation. But they also sort of set that to one side and they say, all right, but that's not the only evidence that matters here. We have this huge body of social science research that shows the harm that is done to black children by being segregated in education. The harm that is done to white children, the harm that is done to American society, our civil society, our life, our culture of opportunity. And Warren famously, when he issues his opinion, is he just says, okay, the historical evidence, thanks a lot, you guys, but it's inconclusive. Like, we can't, like, I'm not a historian. This seems to be a lot of interesting historical evidence, but it's inconclusive. Also, he buys the NAACP's argument. It's not that relevant, right? Like, this is the world that we live in. And if we're going to defer to, 1787 to decide whether racial equality and social equality of the races is a possibility within our constitutional system, we will never move forward as a people, right? Like,
or even 1868, right? Even when the 14th Amendment was ratified, then those who framed it didn't foresee all the changes that they were hoping to enable in these capacious terms of that amendment itself. But yet, then that decision triggered a whole bunch of people who are looking to massively resist it, and it triggers some academics who were looking to find reasons to say, no, this is wrongly decided, and segregation should actually still be at least constitutionally okay.
So there's just some great characters here. One is this guy David J. Mays, who had won the Pulitzer Prize in 1953 for a biography of one of Edmund Pendleton of Virginia,
a year before Brown v. Board was decided.
Yeah, so he was he's a Richmond lawyer. And he's the architect. He goes on after Brown to be the architect of the campaign of massive segregation. He's instrumental in devising that campaign in the Southern Manifesto.
His massive resistance, right?
And everything that follows in the campaign of massive resistance. And he's the person who had prepared the historical evidence in support of the segregated schools argument in Brown. So he's outraged that Warren has dismissed here he is, I'm a Pulitzer Prize winning historian and I've presented all this evidence, and he really devotes the rest of his life to devising a mechanism that can be used as a lever to insist that the Supreme Court not make such decisions going forward, which of course the Supreme Court now is continuing to do. So I think that Mays dies in 1971, but kind of wonderfully, he had kept a really detailed diary his whole life, beginning with his boyhood in Richmond. He writes about in the teens, going to his first lynching, and and how thrilling it was. He writes about taking the train to Washington D.C. to see Birth of a Nation and how great it was. Like, it's a very illuminating. He won't let. He has like a black cook and a housekeeper, and he doesn't want her to go to D.C. for some, maybe it's like a 4th of July parade because she'd get too many ideas about equality if she goes into it gets a very disturbing diary of a quite staunch Southern segregationist. But he contrives to write a series of pieces. He's part of founding this organization on constitutional governance. But he most importantly, he kind of wants to get before a congressional committee or in order to deliver his message. And he does so when Herman Talmadge, the great segregationist, he's introduced an amendment to the Constitution in the House to overturn Brown v. Board by insisting that no state can interfere with the domestic institutions of any the federal government can't interfere with the domestic institutions of any state, and that includes segregation and education. And he calls in David J. Mays to testify, and Mays doesn't really actually have that much to say about the particular question of this amendment, but he publishes his testimony under the title "A Question of Intent." And then he's really active in circulating that and promulgating the theory that the only true and American way and constitutional way of doing constitutional law, of interpreting the Constitution, is by deferring to the original intent. So he's part of a network of Southerners that are doing this work and bringing this argument increasingly to the court over, for the entirety of the Warren Court's time.
And as I was reading your book, I saw a familiar name in there as well, a man named Alfred Avens, who was the founder of my father's law school, Delaware Law School, which is now Widener University School of Law, which I believe could only get it accredited by the ABA if he agreed to relinquish his deanship. And I inherited from my father this book, which you also cite. It's called The Reconstruction Amendment Debates. It's the debates in Virginia's ratification of the 14th Amendment, I believe, and it's selectively edited to further prove Avens's point that he went on to try to impress upon the American public during Thurgood Marshall's Supreme Court confirmation, feeding questions to Strom Thurmond to ask Marshall, almost like a high-profile modern literacy / poll test, asking questions that no one on that panel, not least Thurmond, could have answered himself.
Yeah, so you've said it all so well. So Avens is a sort of a rogue legal academic who kind of bounces around from place to place and is generally drummed out for reasons of concern on the part of the institution about his conduct and about his publications. And he finds his way into Strom Thurmond's office as a staffer. He is really devoted to this project of trying to defeat Thurgood Marshall's appointment to the Supreme Court. In the course of over the course of the 1960s, he then also prepares this really wild set of primary documents that you've just held up, this big volume that, as far as I could tell, Akil Amar told me that Evans had sent it to him as well. He keeps it in his office and it's got this kind of special note. It's like if you could kind of devise a cherry-picked account of how to justify segregation forever, like a George Wallace, segregation now, segregation tomorrow, segregation forever position on the basis of your interpretation of legal documents and public documents, government documents from the 19th century. That would be this volume. I went around and I read all the reviews of it because it was a prominent and interesting, these are obscure documents for researchers, right? So historians get very excited when someone publishes an edit, and historians the reviews are truly damning about what Evans kind of attempted to produce as if this was a definitive, impartial.
Yeah, I've got your book open here. I can
documents.
read one. It said, let's see, the view that the Constitution must be construed according to the intent and understanding of the framers has been unkindly but accurately described as a filiopietistic, did I say that right?
Yeah.
Notion that can have little place in the adjudicative process of the latter half of the 20th century, if indeed it ever did. And indeed, as faithfully followed dogma, it never did. And yet, here we are today, with a majority of Supreme Court justices who do largely faithfully follow this dogma that had shifted from original intent to original public meaning once the intent seemed not to justify the ends results that they wanted. And we have now a court that is dedicated to this as the one true way. You're a historian. I know your focus is on the past, but part of the past is also gives us guidance for the present and perhaps how we can find our ways to a better future. How do we get out of this moment in which, say, a retrofitted originalism that's meant to justify and support Brown v. Board, in which it never did, can give way to a rational constitutional interpretation that leaves room for a pluralistic, multiracial democracy in this country?
Yeah, it's a great question. I mean, I do think it's important to say that just because originalism has racist origins doesn't mean originalists are racists, right? Or that originalism as a theory is, right? These are, people who practice this mode of judicial interpretation they're not promulgating racism. Birth control has racist origins, and people still practice birth control that's not racist. I just think there's a lot of it's really necessary to be generous about what I think is largely a good faith effort. Like, people are, concerned about the role of these people came to power because they were concerned about the power of the Supreme Court and the judicial overreach that concerned them in their lifetimes before they were on the court. And yes, power corrupts. This is a lesson that the framers of our Constitution understood. That's why they set up checks and balances. It's not ultimately surprising that people's positions about judicial review change when they have power on the court and are different when they're, liberals loved judicial review until the court was conservative too, right? No one's winning any blue ribbons for moral consistency here. But I do actually think, and I'm not really a backward looking person, but even though I am a historian, I do think there are lessons to be learned, because in studying the history of originalism, along with other varieties of constitutional interpretation, because it just becomes so much less inevitable, right? It's just utterly contingent. It's an accident of history, really. Reagan didn't have to win in 1980. If Reagan didn't win in 1980, we wouldn't have this court. Mitt Romney might have won in 2012. If Mitt Romney won in 2012, we wouldn't have an originalist. I don't think Romney would have appointed the same kinds of people to the bench. It's like history is a series of accidents, and that isn't to say that there's purposelessness in how we go about seeking change ourselves, but the idea that this is immutable, that this is, I think one of the ways that people get defeated about and powerless in the face of an originalist court that is advancing solely a conservative economic, political, and social agenda is, I think, people worry that the originalists might just be right about how to interpret the Constitution. Like, policy-wise, we disagree with these policies, but maybe they've won the argument about, this sort of Elena Kagan, like, we are all originalists now. Even Ketanji Brown Jackson is trying to use 14th Amendment originalism. And I think the way that you defeat originalism is by not ceding the field to originalists, as if, oh, they are right, this is the one true way to interpret the Constitution. All we can do is kind of use their tools to try to shave around the edges. You can
show
actually
them how
say it's
they're
perfectly
wrong,
legitimate to say this. I entirely disagree with the way that with this as a mode of understanding our Constitution, its history, and its relationship to the present. I mean, I spend a lot of time at the beginning of this book trying to articulate what I think of as the philosophy of amendment. That our Constitution as a written document is founded on the idea that if you're going to write something down, you have to be able to amend it because it can't be frozen in time. There's such a rich, huge, really quite beautiful and inspiring evidence for how deep a belief that was in the states and in the federal government at the time of the founding of the United States. How continuous a belief that has been across American history, especially on the part of people who were left out of the original constitutional dispensation. And I don't know, I feel like, so don't just roll over.
Yeah. And listen, we're almost at 20 minutes now, and this has been an amazing discussion. And I could talk with you for hours about everything you've just said, because each thing you say opens up a new pathway to talk. But on the amendment process, just one final thing. we are at a position now where we always talk about amendments being virtually impossible to ratify, either because of the polarization within Congress, even Senate of the states, or polarization or the polarization among the states, so you can't get to 3/4 of states required to ratify. And into that breach has stepped the Supreme Court in a lot of areas of constitutional law. How do we open up the vista again to a depolarized, unpolarized populace where we couldn't imagine a constitutional amendment passing? And would it have to be a deeply unpolarizing amendment itself? And then
so I think that the way we get there is honestly by not nationalizing all political questions, and instead thinking locally. My my city, on our ballot a couple weeks ago, there was a question about what the relationship between the city manager and the city council should be, and people were asked to think about that. We had all these other ballot initiatives that are really kind of about fundamental ways in which our city is governed. I think get involved in your community and in your neighborhood, in your city, in your town, in your county, thinking about, is our state constitution working well for us? Is our city charter does it need updating? Is it great? Should we celebrate it? Should we be doing more to teach kids about why our city charter is the way it is, or why we have a county government? Or I just think actually building back civil society and our ability to participate with one another with warmth and generosity and spirited debate and inquiry and curiosity together about how we even govern ourselves at the local level is how we build back the skills, the kind of democratic capacity to do things like think about, well, I wonder if actually the US Constitution might need amending, or maybe it doesn't, or maybe I want to run for office, or maybe I want to support somebody different for office who has a vision for some kind of constitutional change that involves a mechanism other than going to the court. Maybe not, but I don't think I don't think you can run before you walk. And I kind of think we have to first kind of get out of bed.
Professor Jill Lepore, thank you so much for joining us here at Legal AF on Midas Touch Network. My name is Mike Sachs. Hit that subscribe button. Keep watching. Thanks for being here. Bye-bye.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.